Hello, everyone, and welcome to this Judicial Retirement Benefit Overview. This presentation is a general overview for judicial retirement benefits. It does not cover a regular superannuation retirement benefit. Judicial members should consult directly with MSRB staff or refer to Massachusetts General Law, Chapter 32, Sections 65A through 65J with any specific questions. In this presentation, we'll go through eligibility and plan rules. We'll talk about benefit calculations. We'll cover the application process, and then we'll finish it off by covering post-retirement matters. Here are some links to Judicial Statutes, Sections 65A through 65J of Mass General Law, Chapter 32. Here's a general update. The board's telephone hours are 8 a.m. to 5 p.m., Monday through Friday, except on state holidays. We will communicate any future changes via our website, social media channels, and newsletters. We offer limited drop-off hours Monday through Friday from 10 a.m. to 3 p.m., except on state holidays. Members can drop off completed retirement applications, forms, and other documents at either the Boston or Springfield office. Our Boston office is located at 1 Winter Street, Downtown Crossing. Our Springfield office is located at 436 Dwight Street, room 109A. You can check our website regularly for updates, mass.gov/retirement. Members of the Massachusetts State Employees Retirement System are assigned an MSRB ID number. Your MSRB ID is your unique retirement account number. For security purposes, it is used instead of your Social Security number. It is not the same as your employee ID. Your MSRB ID number is printed at the top of every letter you receive from the Retirement Board. The State Retirement Board is a statutory authority, and the plan rules are governed by Massachusetts General Law, Chapter 32. For the judicial retirement benefit, it is through Section 65A through 65J. The judicial retirement benefit is a traditional defined benefit plan. Code Section 401A, Retirement Plan, under Code Section 414D of the Internal Revenue Code. Accruing service toward eligibility for a judicial retirement benefit does not carry any membership rights associated with non-judicial benefits under the Massachusetts State Employees Retirement System. The contributions are based on when you were appointed. If you were appointed before January 1st, 1975, or if you are a Justice of the Supreme Judicial Court appointed to the SJC before July 1st, 2010, you are not required to contribute. If you were appointed between January 2nd, 1975 and December 31st, 1978, the contribution rate is 7%. If you are appointed between January 1st, 1979 and December 31st, 1987, and did not previously work for the Commonwealth or political subdivision thereof, the contribution rate is 7% plus 2%, 7 on the first $30,000 and 9% over $30,000. If you're appointed after January 1st, 1988, and did not previously work for the Commonwealth or a political subdivision thereof, for the first $30,000, the contribution rate is 8%. On the next $30,000 until $45,000, the contribution rate is 9%. And from $45,001 and over, the contribution rate is 10%. Contributions are managed and invested by the Pension Reserves Investment Management Board, or PRIM. If you have questions about how your contributions are being handled, you can reach out to PRIM via their website, www.mapension.com. Now, there are limits on compensation. State law limits the amount of regular compensation that may be used in determining a retirement benefit for certain members of the MSRs. The state compensation limit applies only to individuals who became members of the MSRs after January 1st, 2011. Regular compensation in any calendar year that may be used when calculating retirement benefits under Chapter 32 may not exceed 64% of the annual federal limit that may be used when calculating benefits under qualified plans. For 2025, the general compensation limit found in USC 401A-17 is $350,000, as outlined in PARAC Memorandum Number 4 of 2025. Thus, the 2025 limit on regular compensation under General Law 32 for persons who became members after January 1st, 2011 is $224,000. If a judge has prior membership in the MSRS or another Massachusetts public retirement system before January 1st, 2011, and prior to becoming a judge, the state compensation limit would not apply. The Commonwealth's HR CMS payroll system currently addresses the compensation limit for employees affected by it, and annually halts retirement contributions on regular compensation amounts over the limit. Please contact John Borak if you have any questions. 617-591-8935. Let's go over eligibility and plan rules. For service prior to becoming a judge, non-judicial service may not be transferred into or used in determining judicial retirement benefits. A judge who previously requested a refund or rollover of retirement contributions related to prior non-judicial public service may not be eligible to reinstate or buy back such service unless they reestablish membership for non-judicial benefits within the state employees' retirement system or another Massachusetts public retirement system. To then be eligible for a non-judicial retirement benefit, in general, a judge must return to non-judicial active service to complete a buyback, and then work for at least 2 consecutive years before they would be eligible to retire under a regular superannuation. For 2 pensions, a judge who becomes vested under Section 5 or Section 10 of a Chapter 32 retirement system and is or becomes eligible for a judicial pension pursuant to Sections 65A, 65D, or 65H is eligible to receive 2 pensions. The effective date of the deferred pension cannot be prior to the effective date of the other pension. Judges cannot begin collecting their non-judicial pension while still actively serving as a judge. For spousal survivor benefits under Section 65C, under Section 65C, if a judge would have been entitled to a retirement allowance at the time of death, the spouse would qualify to receive an allowance. If a judge does not qualify for a retirement allowance at the time of death, the spouse would not qualify to receive an allowance, and the funds in the judge's annuity account are returned to the estate. For survivor benefits in pre-retirement death under General Law Chapter 32, Section 65C, Section 65C outlines how the pension or retirement benefits will be calculated in the event of death. A surviving spouse is the only beneficiary eligible to receive a benefit calculated under the provisions of Option C. Under Section 65C, if the judge was otherwise eligible for a retirement benefit by meeting both age and service requirements at the time of death, under Section 65C, if the judge otherwise met service requirements at the time of death, but had not met certain age requirements, the spouse may be eligible for a reduced survivor benefit. The reduced survivor benefit for life is equal to 2/3 of the retirement benefit to which the judge would have been otherwise entitled. Section 65C provides for benefits only for surviving spouses under different circumstances. You cannot elect anyone else. The spouse would receive 2/3 of the benefit the retired judge was receiving at the time of the judge's death. If the spouse predeceases the retired judge, the benefit converts to the Option A benefit amount prospectively. For example, a judge who resigns and/or retires and is entitled to a pension or retirement allowance under Section 65A, 65B, 65F or 65I may elect option C to receive a lesser annual rate so that, at their death, their surviving spouse would receive a retirement benefit for life. Under certain circumstances, the accumulated contributions will be returned to the estate of the deceased judge. For example, if the judge has less than 10 years of creditable service or does not have a surviving spouse. Under Section 65C, when a member retires and chooses option C, if their beneficiary predeceases them, the member's benefit would pop up to option A and be paid until the member died. Alternatively, if the member dies first, the joint and last survivor allowance is paid to the beneficiary until the beneficiary passes away. If the parties were to die at the same time, there is no benefit to pop up, and no survivor benefit to be paid, so the benefit would simply stop. No further benefit is paid to anyone else because the law doesn't permit the member to change their option or to change their beneficiary when option C is chosen. Let's go over benefit calculations. For a judge retiring at age 70, the mandatory retirement age, with 10 years of judicial service only, 75% of the annual salary at retirement. For example, 75% of $207,855 would equal $155,891.25 for the gross annual benefit. If a judge reaches age 70 but does not have 10 years of judicial service, a reduced benefit based on their creditable judicial service in years and months is multiplied by an age factor of 7.5% and is calculated per Mass General Law, Chapter 32, Section 65D, lower d. For example, 8 years and 6 months of judicial service at age 70 would be calculated as 8.5 multiplied by 7.5%. which would equal 63.75% of the annual salary of $207,855. This would equal $132,507.56 of the gross annual benefit. For a judge retiring at age 65 or older under Section 65D, they must be aged 65 through 69. Beginning at age 70, only 10 years of creditable service is required. For a judge retiring at age 65 or older, it does require a minimum of 15 years of judicial service to obtain the maximum benefit. They would be eligible for a retirement benefit equal to 75% of their annual salary on the date of retirement. For an early retirement provision for a judge retiring at age 55 or older under Section 65H, you must have a minimum of 10 years of judicial service. The allowance is the salary at retirement, for example, $100,000, multiplied by the number of years of judicial service, for example, 10, multiplied by the percentage allowable based on the age at retirement, for example, 1.5%, as shown in the statutory table on the next slide. In this example of 100,000 multiplied by 10 multiplied by 1.5%, it would equal $15,000. The maximum allowable allowance is 75% of the annual salary at retirement. This benefit is in lieu of benefits under Section 65A, 65B, or 65D. And here's the statutory table that was referenced on the previous slide. So in the example that I provided, where the percentage was 1.5%, the age at date of retirement would be 55. For deferral of retirement, a judge may qualify for a deferred retirement benefit under Massachusetts General Law, Chapter 32, Section 65H, with the required creditable service of 10 years, after separating from employment upon reaching the required minimum age of 55, and if they have left retirement contributions on account with the retirement board. Members do not have to notify the board that they are deferring their retirement. It is important not to take a refund. For retirement due to disability or advanced age, judges may be removed by the governor with consent of the governor's council and after notice and hearing due to the judge's advanced age or physical disability. Otherwise, judges are required to retire at the age of 70. The retirement date would equal their 70th birthday date. For disability retirement under Chapter 32, Section 65I, judges may apply for ordinary or accidental disability retirement benefit because of a mental or physical disability under General Law, Chapter 32, Section 6 or Section 7. A judge must satisfy the statutory eligibility requirements. Disability retirement benefits are in lieu of any other judicial retirement allowance. For the return of contributions, any judge who is not eligible for a retirement benefit will receive a refund of their contributions plus interest upon request. A judge may have the funds in their judicial retirement account transferred to any other Chapter 32 retirement system in which they are active or inactive, so long as they do not meet the requirements for retirement under Section 65D. For domestic relations orders, a judge who is party to a domestic relations order or DRO should submit a draft DRO to the board's legal department for review as to its form and implementation before execution and approval by the probate court. You can submit domestic relations order drafts to the legal department, msrb-legal@tre.state.ma.us. Let's talk about the application process. The retirement application may be filed 120 days before or 60 days after your last day on payroll. You can file more than 60 days after your last day, but the effective retirement date will be 15 days after filing. You can withdraw the application anytime up until the day of retirement. No changes can be made after your retirement date has passed. Required is the application itself, option form with witness signature. If you are married, your spouse must witness the option form. If you are not married, you still need to have a witness sign the option form. The W-4P tax form, the direct deposit form, authorization for filing information electronically, and copies of any required documents such as birth certificate, marriage certificate, DD-214 if you're a veteran, etc. Under Chapter 32, Section 65H, the retirement options are Option A, the highest benefit calculation. All benefits cease upon death. There is no survivor benefit. Option B, which provides for a lump sum distribution of remaining annuity funds, and it is only available to judges retiring under the provisions of Section 65H. And Option C, which is an average 7 to 15% reduction in the benefit. You will automatically pop up to Option A if the beneficiary predeceases you, and it factors the nearest birthday in calculation. For health benefits, health, dental, vision, and life insurance for GIC eligible public employees is administered by the Massachusetts Group Insurance Commission, or GIC. They are a separate state agency. Employees must notify the GIC of their retirement by logging into My GIC link, GIC's member benefits portal at the link provided, and submitting a qualifying event retirement application. Employees also have the option of submitting a GIC employment status change form using their online forms or their print forms. For any questions, you can contact the GIC by filling out their online request form. You can also call 617-727-2310. Per GIC, if you have any questions about turning age 65 and Medicare enrollment with GIC health insurance coverage, they have a short video on their website as well as an FAQ page. Let's talk about post-retirement matters. A judge becomes eligible for a cost of living adjustment, or COLA, On July 1st, if retired a full calendar year, COLAs must be annually authorized and enacted by the legislature and governor. Historically, the COLA has been up to a 3% increase of the first $13,000 of the pension, currently $32.50 per month, or $390 annually. For working after retirement in a non-recalled position under Chapter 32, Section 91A, the general rule applies to governmental employment, municipal, county, or state, not to exceed 1,200 hours in any calendar year. Earnings cannot exceed the difference between your retirement pension and what a judge's position is currently paid. Special provisions apply to judges who are recalled in that capacity. For working after retirement with a judge that has 2 retirement benefits, if the retired judge is working in a non-recall capacity, you would average the earnings limits of the retired judge by taking the average retirement benefit of the 2 allowances and an average of the salaries of the former positions, judicial and non-judicial, used to calculate the retirement allowances to establish a limit under Section 91B, and you would maintain the annual hour limit of 91B. A judge that is receiving both a judicial and non-judicial retirement allowance will need to consider both their judicial and non-judicial current annual salaries and retirement allowance amounts. To determine the earning limits, they will need to add together the gross annual amounts of both retirement allowances and divide by 2 for an average. Then, add together the total current annual salaries for a judge and their non-judicial title and divide this by 2 for an average. Subtract the total annual retirement allowance average from the total current salary average to reach the earnings limit for the calendar year. For a judge working with 2 retirement benefits in a recall capacity, you would implement the provisions of Chapter 211B, Section 14C for the judicial benefit, but also include the annual non-judicial retirement benefit received toward the 14C limitation. For state and federal taxes, on appointments made before January 1st, 1979, a judge who did not contribute to the retirement system will pay both state and federal taxes on the pension received. On appointments on or after January 1st, 1975, a judge who contributes to the retirement system is required to pay federal taxes only. Tax credits are allowed from any after-tax contributions that may have been made. On those appointments made after January 1st, 1975, it's important to note that there are no state taxes in Massachusetts on your pension. It is federally taxable. There are 15 states that will not tax the pension. Those are the states that we have listed here and highlighted on this map. If you move to a state not listed here, you will need to reach out to that state's Department of Revenue, the IRS, or a tax professional to determine the tax liability living in that state. The State Retirement Board is not a tax authority. We are not authorized to provide you with any tax advice. Vacation and sick pay is handled by the department or agency from where the member is retiring. Under Section 65J, upon retirement, a judge shall be paid an amount equal to the vacation allowance as earned in the vacation year prior to such retirement, provided, however, that no monetary or other allowance has already been awarded for such vacation allowance. Upon retirement, a judge who has accrued unused sick leave credit shall be paid an amount equal to 20% of the value of such credit as determined by the rate of compensation received at the time of retirement, provided, however, that such payment for accrued unused sick leave shall not affect the amount of retirement allowance available to such judge. For Social Security, the Social Security Fairness Act, or H.R. 82, which concerned the windfall elimination provision, and government pension offset was signed into law on January 5, 2025. Upon implementation, the Act eliminates the reduction of Social Security benefits while entitled to public pensions from work not covered by Social Security. Social Security is a federal benefit that has nothing to do with state pension benefits. This change in federal law will not impact Massachusetts state, municipal, city, or town pension benefits. For more information, please contact the Federal Social Security Administration. We did provide a link to their website where they have additional information about the repeal of the windfall elimination provision and the government pension offset. You can contact Social Security via their website, or you can call 1-800-772-1213 between 8 a.m. and 7 p.m. local time, Monday through Friday. Wait times to speak to a representative are typically shorter in the morning, later in the week, and later in the month. Automated telephone services are available 24 hours a day and do not require you to wait to speak with a representative. You can visit our website, mass.gov/retirement, to view additional information about the Judicial Retirement Benefit. We have a dedicated page on judicial benefits. You can follow us on social media such as X for all the latest stories and news, or you can post at us with any general questions. You could also follow us on Facebook, which is home to our live show, Monthly Coffee or Tea with MSRB, hosted every first Wednesday at 10 a.m. Our YouTube channel is home to instructional videos, archived webinars, and our coffee or tea archive. If you have additional questions, you can contact either our main office in Boston or our regional office in Springfield. Our toll-free number within Massachusetts is 800-392-6014. Our main email is srb@tre.state.ma.us, or you can email msrbcommunications@tre.state.ma.us. Here is also contact information for the trial court and appeals court. Thank you very much. Have a great day.